On March 20th, 2025, Byron Laws appeared before Judge David Fletcher in Harris County Criminal Court in Houston, Texas. He had originally been charged with driving while intoxicated with a blood alcohol level above 0.15 stemming from an arrest on October 5, 2021, and the case was still unresolved. At this hearing, Mr. Laws was represented by newly appointed defense attorney Anna Eddy. After reviewing the case file, she asked the court to revisit whether there had been probable cause for the original warrantless arrest. Her request is rooted in the U.S. Supreme Court's 1975 decision in Gerstein v. Pugh, which held that when someone is arrested without a warrant and charged by a prosecutor, they are entitled to a prompt judicial determination of probable cause. The court made clear that a prosecutor's decision alone is not enough. A neutral magistrate must review the basis for the arrest. Texas law reflects this requirement in Article 14.06 of the Code of Criminal Procedure, which mandates that a person arrested without a warrant must be brought before a magistrate without unnecessary delay, and no later than 48 hours after arrest. Although a probable cause review would normally have occurred back in 2021, Ms. Eddy asked Judge Fletcher to reassess whether probable cause truly existed.
I'm approaching on Laws.
Okay.
Is the last name. He's on bond.
Okay.
He has a BVR, but can we hear PC on this one?
Sure.
Sorry.
You don't think there's PC?
Laws. Yes.
You don't think there's PC?
I don't, looking at the DIMS, but reasonable minds can disagree, Judge.
Have we done PC on this before?
I don't know. This is an older case and I just got appointed on it last month. So.
Did you already approach on PC on this?
I have not.
Don't worry about it.
I'll just be honest, Judge. I had assumed because of the age of the case that PC had been done. But
Of course it has been.
right.
But there's a new set of eyes, you know? Okay, ready?
Yes, Your Honor. Sorry, just reading through it. 2021 case. On October 5th, 2021, the officers were dispatched to a DWI call. The officers were dispatched to a possible intoxicated driver call. The witness stated he observed the defendant to go in and out of lanes while making a U-turn on the highway, hit traffic. The officers conducted a traffic stop. The officer observed the defendant to have glassy eyes, slurred speech, and odor of alcoholic beverage and poor balance, and a order hold. Quiet, please. Hold beer inside the vehicle. The FMSTs were conducted. It was a 6 out of 6 on the HEN, a 7 out of 8 on the walking turn, and a 4 on leg stand. The breath is a 0.15.
So according to the DIMS, which is the sworn statement that we use for PC, it just says the officers initiated a traffic stop on the defendant's vehicle at an address, and there's no reason given in the DIMS for the stop.
She read something different.
That was
Yes.
not in the DIMS.
That seems to be from the offense report.
Sure, I mean, what's...
But I thought for PC, we just used the DIMS because that was sworn to, and not getting into the.
Show me where it says that. I don't know of any rule that says that it's PC has to be done on just the DIMS.
Okay.
You know, I don't. If you can direct me to something,
Okay,
but I've
and
never.
that just may be my misunderstanding of a
Yeah,
policy.
I don't. And I've heard this before.
Okay.
Right, but I can't. I've never seen anything where someone has ever directed me to saying, "Hey, PC is only
Well, it's
has to be just on the DIMS." You
because
know.
the DIMS is sworn, and just like when Judge Powell was up here and he wanted to get into the facts, he couldn't.
I mean, if he's getting into the facts, then that's something different, right?
Well, and getting into
Sworn document too.
the offense report's on a sworn document.
I mean, I guess, Your Honor, my thing is it's a public record that they're using DIMS taking the offense report. And also, I have never seen a rule where we have to rely solely on the DIMS for public policy. It's probably law. In fact, when we go to the grand jury, that's all offense report, that's all DIMS, it's everything that comes in, it's even evidence. And that's probable cause.
Yeah, I don't know. I don't think that. I mean, let's look because I don't know. You know.
Okay. I'll stand
And
down.
I'll
Go check with
sure.
Ms. Rogers.
The defense argued that the probable cause determination should rely strictly on what was written in the DIMS record, not the later offense report. DIMS, the District Attorney Intake Management System, is the electronic platform officers use to submit charges to the Harris County District Attorney's Office. In warrantless arrests, officers consult a prosecutor for charging approval and then complete a detailed electronic entry including the facts of the incident. The DIMS manual requires a concise narrative describing who, what, when, where, and how the alleged offense occurred, and it specifically states that simply referencing a police report is not sufficient. The facts must be written directly into the system, and once submitted, they cannot be altered. By contrast, an offense report is a fuller narrative created after the arrest and can be updated as new information emerges. Ms. Eddy's position was that only the sworn DIMS facts could legally support probable cause, and in Mr. Law's case, she argued those facts were insufficient.
So you're saying that the DIMS has no reason for the stop, right? Is that what
Yes.
you're saying?
The sworn statement, and speaking with Ms. Rogers, we're looking, but it's not,
And I'm looking to.
okay.
I am too.
There was a class action lawsuit, and as part of the settlement, the agreement was that Harris County would use the DIMS to support
Okay,
PC, but we're getting that all together.
me too.
Okay.
For the 26th.
Was there a result for that?
Yes.
Or is it in action now?
No,
No, this was some time ago. So this was before the DIMS summaries had an oath or affirmation at the bottom of it. So there was a class action lawsuit brought by the Civil Rights Court. And out of that lawsuit, it was just allegations of Fourth Amendment violations, because when a warrantless arrest occurs, the Fourth Amendment requires that a neutral magistrate make a finding of probable cause supported by oath or affirmation. So as a result of that lawsuit, Harris County settled and said, okay, we're not going to concede that we were violating the Fourth Amendment, but we will now include an oath or affirmation. So I think it is a Fourth Amendment issue.
I'm curious, so I'm curious, for PC purposes, can state use an offense report to supplement a DIMS? Or are we strictly going in the four corners of the DIMS and nothing else? I don't know.
well, the four corners of the DIMS is what's sworn to. The offense report is not.
I find that really weird. How is it that they're creating an offense report and they don't swear to it? You know, because there's, in the offense report, you also have a search warrant. Like 9 times out of 10, you've got a blood search warrant, and that's sworn to.
That, Your Honor, if the officer makes something up into the office report, he is committing a crime. So, I mean, I don't say that the office report is not sworn to. It's a government record that this officer is putting his name on. If he makes something up or if he lies about something, that is a crime.
Right, but filing a false government document is a different crime than perjury.
I get it, but
Wouldn't that be filing a false,
Right, but perjury's
an official document?
a different crime.
No, but it would also under the purview of filing a false,
Well, Judge, if an officer came into court and was asking for you to sign a search warrant and they just gave you their offense report, that would not be enough for their search warrant. And it's kind of the same idea. Because this is a warrantless arrest, there has to be someone swearing to the facts to support probable cause for that arrest. And similarly, with the search warrant, it has to be supported by oath or affirmation. This wasn't a warranted arrest, it was a warrantless arrest. And so it must be supported by probable cause. That includes an affidavit.
was there blood in this case? Right. Okay, give me 5 minutes.
Okay.
and Your Honor, it's lawful.
Huh? Okay,
If it's okay with you, we'll take.
can you show them?
Yeah, that's fine. Yeah,
The defense also referenced the federal civil rights case Lester versus Harris County, often cited regarding probable cause practices, filed in 2016. The lawsuit alleged that the county's procedures allowed people to remain detained without a proper judicial finding of probable cause, because the DIMS entries were not sworn statements at the time. The case was settled in 2017. While the county did not admit wrongdoing, it agreed to modify its procedures so that officers must affirm under penalty of perjury that the facts entered into DIMS are true. This change ensured that probable cause determinations would rely on sworn statements.
Anna, you ready?
Yes, Judge.
Mr. Laws, come up. We have court orders for a reason. And when you don't follow court orders, bad things happen. Do you understand?
Yes.
You were ordered to get an interlock and you didn't get it, or a portable device and you didn't get it. That's unacceptable. When you don't, there are serious, serious consequences. The only thing I'm asking you to do, don't endanger my streets. Don't kill someone on the road. Do you understand?
Yes, sir.
I'm going to find no probable cause in your case now. But if you come back with a new case and you don't follow court orders, it's really not going to go well for you. Do you understand?
Yes, sir.
All right. Good luck.
Thank you, Judge.
We were going through the lawsuit and, 2017, the county came into an agreement where we're basically holding it to a higher standard, so to speak. I mean, theoretically, could I weasel out of it? Yes, but I don't want to. I want to stick with the agreement that the county came to with the district attorney's office,
I'm not saying this, I'm just for curiosity.
Yeah.
Just
The DIMS has to state an offense, right? It has to have all the elements of the offense to go forward. The reason, I would presume that offense reports don't is because they're continually just updated and they're amended and they supplement it. So it would be unreasonable to have an officer every single time they swear to over and over and over and over, because you might get like 15 supplements.
And here's my question then for the court, and I'm not saying we do this in this case, I'm just saying for cases going forward. To me then, does that then behoove, does that say we can't take it to grand jury?
You can, of course you can.
So,
Yeah.
Just because I find no probable cause on something, if you want to go indict it, go do it.
right, okay.
Absolutely. There's nothing barring you from doing that, right? Because if a grand jury finds something different, then that's on them. As far as me, I'm going to just hold to the standard that we agreed with the county in the lawsuit.
I'm just, and this is for my own.
And you're not going to hurt my feelings if you go to a grand jury. I don't care.
I know you, Judge.
Really.
So we wouldn't be held to that same standard at grand jury.
You need to do what you think is right.
Okay.
Like I'm going to do it, and like she's doing it. The problem is that whoever had the apps, they didn't dive into it and really look into it as Anna did. Not everybody is,
This is required to them.
I understand.
which is good.
Thank you.
God love you.
After reviewing the sworn DIMS entry, Judge Fletcher concluded that it did not establish probable cause for the charge. However, because the case had been filed by information, he noted that prosecutors still had the option to seek an indictment from a grand jury. In Texas, a grand jury of 12 citizens decides whether enough evidence exists to formally charge a person. If at least 9 jurors agree, they return a true bill, creating an indictment. If not, the case ends with a no bill. Following the ruling, prosecutors moved to dismiss the existing charge while reserving the right to refile. The court granted the motion, and the case was formally dismissed. As of the time of this narration, the charge had not been refiled. This case underscores how critical constitutional safeguards are in the criminal process. Probable cause requirements are not mere technicalities. They protect individuals from unlawful arrest and help maintain public trust in the justice system. Ensuring that charges rest on sworn, sufficient facts preserves both defendants' rights and the integrity of the courts.